Cora, we go back over to you. Danny's mother passed away in March. She asks, apparently her mom and her sister, Danny's aunt, owned the house in joint tenancy. Tenancy? Tendency. Am I right? Yep.
Yes.
So Danny is wondering if her aunt is the sole owner of the house. She says her mom left everything else in the will to Danny herself. Thoughts?
Great question. And I absolutely love estates. I have a passion for serving those fiduciaries, especially in this time of need. And when they're trying to move that real property, it is uber important that we have the correct representative and that they have authorization to act. So in your fact pattern, Bob, you said you had two people initially on the deed to the house, and one of them just passed away. Now, you mentioned joint tenancy. So I want to make a clarification here. Under Kentucky law, if the words joint tenants with rights of survivorship or a very similar variation is not included, the default manner in which more than one person will hold title to a real property is going to be tenancy in common. So what does that mean? Okay, well, let's just use Bob and I as an example. So Bob and I own a property. We really don't. But if we did and we owned it as tenants in common, or in your scenario, it just says joint tenancy, that's not enough. It has to say joint tenants with rights of survivorship. That second piece has to be included in there. So therefore, in your example, it's going to be tenancy in common. If Bob or I die, our interest in that property goes to our heirs under intestacy laws, according to Kentucky's laws of descent and distribution, if I did not have a will, or our will, okay, and what that our heirs may be or beneficiaries may be that we have included in our last will and testament. Now, if you conversely owned title as joint tenants with rights of survivorship, Bob and I own a property as joint tenants with rights of survivorship. One of us dies. Our interest automatically at death goes to the surviving member. If I die, my interest automatically goes to Bob. At death, it's a non-probatable asset. It doesn't matter what Kentucky's intestacy laws say if I don't have a will, nor does it matter what my will says if I did have a will, because that asset is controlled by titling, and therefore it flows outside of the estate. So in this scenario, in thinking that they just have one person that they're dealing with now, and that is the sole title holder, that would be incorrect. Because if it just says joint tenants, I just told you that the default, because it was incorrectly drafted, will be tenancy in common. So we now have to ask questions for that decedent, okay, such as, is there a will? Has it been probated? Who is authorized to sign on behalf of the estate? Is it an executor, executrix? Does the will have power to sell real property? If they don't have a will, are we opening an estate and we have an administrator appointed to get in order to sell real property, and so on and so forth? So you can see that that opens up a whole nother can of worms and a whole nother layer to that onion that we have to peel back. Whereas if they held title as joint tenants with rights of survivorship and that deed was correctly drafted to reflect so, then of course their presumption would have been correct and they would be dealing with one sole title holder. And by the way, their spouse, if any, because we're dower law now, right? We have one title holder. We have a dower interest to account for.